Hello and welcome to our session for today. So today we are going to look at a revision for KNEC Diploma. The particular unit is actually business law. We're going to revise a question that was actually tested in the year 2022, November. So that is a KNEC business law paper. So if we can be able to share the question, it is the first question for that particular paper. It is for KNEC Diploma in Supply Chain, Diploma in Business Management, amongst others, Module 1. So we're going to look at a specific question, that is question number 1A. Question number 1A. So this particular paper is for November 2022. So the question reads like this. So if you can be able to see question number 1A. So it says, explain 4 circumstances under which African customary law is applicable in Kenyan courts. So 4 circumstances under which African customary law can actually basically be applied in Kenyan courts. So when you talk about the African customary law, so it is just one amongst the other sources of law. So African customary law, it is just one amongst the other sources of law. So it is one of the sources of law. So it is a basis upon which judges in a court of law can be able to rely upon to be able to make a ruling or a determination or a judgment in a court of law. So this African customary law is actually based on the customs or traditions of the African people, So it is basically law relying on the customs of the African people. So these customs are the ones that are being applied as a source of law. So for these customs to be applied as a source of law, then of course they should actually be able to meet certain requirements. Not all customs will basically be applied as a source of law. So the first thing that this particular custom should actually basically be having as an element or a characteristic, number 1, the custom should actually be consistent. It should be consistent with the supreme law, When you talk about the supreme law here, you simply mean a custom should actually basically be consistent or in sync with what is actually provided for in the Constitution, because the Constitution is the most supreme law of the land. So if that custom is not actually consistent, then it can't actually be applied as a source of law in a court of law. Number 2, this particular custom must have just been exercised as of right. It must have just been exercised as of right. And in this case, there hasn't been any form of coercion for anyone to be able to adapt the custom. Not that the custom is actually basically being forced on people to be able to apply it. In such a case, it cannot actually basically be recognized as a source of law. So it must be a custom that has been exercised as of right and not any form of coercion in having to be able to apply it as a source of law. So it must have been exercised. It must be a custom. A custom being exercised as of right, a custom being exercised as of right, and not any form of coercion. Number 3, this particular custom must be one that has been practiced since time immemorial. So for a very long period of time, so you can't actually be able to tell the origin. So it has been passed on from generations to generations. It must be a custom that has been practiced. Must be a custom that has been practiced, that has been practiced since time immemorial. So it must be one that even if you ask your father or maybe your forefathers, they can't actually be able to explain clearly where it actually originated from, but it has been passed on from generations to generations. So you can be able to talk about, for example, a custom about having to pay dowry for different communities. So you can't be able to tell the exact origin, but that basically has been practiced from time to time. Then the last one, this particular custom shouldn't actually basically be against the principles of natural justice. For example, now in this case, if a matter is to be determined before the court, then for example, now in this case, there are certain rights that are supposed to be enjoyed by the parties. For example, the right to be heard, the right to be represented, the right, for example, to present evidence. So the customs should actually be ones that are not actually basically against the principles of natural justice. So if a custom basically meets all these particular requirements, then of course it can actually be applied as a source of law, and therefore it will be recognized as an African customary law. It can be recognized as an African customary law, therefore applicable in a court of law. So that's all about that particular question, and that was how you can actually be able to answer the question. So that is how you can be able to answer the question. So the class has come to you courtesy of RCM Online College. We offer KNEC courses, and in any case you want to be able to enroll for our classes, you can simply reach out to us through our contact, which is 0719 525,000. And of course, you'll be able to enroll and actually enjoy our classes. Thank you very much, and we will meet in another session.